Hello everyone, I am Meenakshi and I welcome you all to Tathastu, and our today's topic is Right to Information Act of 2005. So it is clear from this only that the act was implemented in 2005. So today we will be discussing about this RTI Act. It is more popularly known as this RTI Act of 2005. So we will be discussing how it is implemented, have it been amended, how many times it has been amended, what are the controversies related to it, and what are the features of this act, what are the objectives of this act. So we will be discussing all that in detail. But before that, these are the courses which are offered by Tathastu-ICS for all of you. There's MSLV for mains examination. Admissions are open. You can get yourself enrolled. Then there's NCRT module. You can register for it. Then this is PSLV for your prelims examination, which will be launching super soon. And then there is your philosophy optional by Tanu ma'am. So if your optional is philosophy, you can get yourself enrolled. So let's begin the lecture about the Right to Information Act, and as I said, it was implemented in 2005 and it is more popularly known as this RTI Act. If we talk about the acronym, the short form, it is the RTI Act. So before starting, see, India is a democracy. It is a government of the people, for the people, by the people. So we are the common people and we have every right to know about what decisions are what decision is being taken by the government, and what are the justifications they give for that decision, so that we can also make informed decision. So this RTI Act was brought for all that, so that we can get information about those decisions which are not available in public domain. So we can file an application and then we can get the information about that particular thing on which we want the information regarding the decisions taken by the government. It is very clear from the word only, this act only, that the right to get information about the various decisions. So this Right to Information Act of 2005, it helped the citizens obtain information and data from central and state institutions that are not readily available in public domain. So as I said, that this RTI Act of 2005, okay, just a little bit of information more, that before this there was an act which was introduced way back in 2002, but it was not implemented because of this lack of infrastructure, and in that slow place, this Right to Information Act was introduced for the citizens, so that they can obtain information and data from various central level and state level institutions, and the data which is not readily available in public domain. So the citizens can access that data through this RTI Act of 2005. I hope the definition is clear to all of you. Now moving on, this act allow any citizen, so this can be an extreme statement. There are few extreme words which our UPSC can put in any statement. For example, this any, only, every. So these are some extreme words, so we should pay attention while reading about these words. So this RTI Act allows any citizen to make request for access to data, documents, be it central level institution, be it state level institution. So request for access to this data, documents and other information in the government's possession. So this is what this RTI Act says. Now this India's RTI Act has been commonly cited as the most comprehensive public records access legislations in the world. So this is a very important act which was introduced way back in 2005 for the citizens' rights, so that they can have the knowledge about the decisions which the government are taking, the expenditure, or on that basis they can make these informed decisions. Now moving on, this law was passed. If we talk about objectives, every act, every law has an objective which needs to be fulfilled. So this law was passed to strengthen the fundamental freedom of speech guaranteed in Indian Constitution, and this freedom of speech and expression is constituted under Article 19 of the Constitution, and Article 19 is a fundamental right. So if we talk about RTI 2005, this law was passed to strengthen the fundamental freedom of speech and expression which are implicit in the Constitution under Article 19. Now RTI is an implied fundamental right, as I said, because it gives us to this freedom of speech and expression, and this freedom of speech and expression is a fundamental right. So RTI is basically an implied fundamental right because it is included in right to freedom of speech and expression under Article 19 of the Indian Constitution, as I said. So I hope this is also clear to you. Now moving on, talking about the amendments. Amendment means any changes. So after 2005, are there any changes which have been introduced in this act? Yes, there are changes. Amendments have been introduced in this act. Which act? RTI Act of 2005. Now under this act, certain information. So we are talking before the RTI Act of 2005 over here. So when this act was introduced, certain information could be kept under wraps, reason being given the national security and sovereignty. So if a citizen files an RTI and want information on some topic, but government may deny it on the basis of this that it is related to national security or the sovereignty of the country. So this was in 2005. So there was an exemption also, that prohibition of personal data of citizens could not be released unless there is an overriding public interest in doing so. So we have this, our personal data is with government. We mention about our data at various places. So under this act, there was this prohibition that personal data of citizens could not be released. So this was a qualified exemption. Qualified exemption in the sense meaning that there was one case where this data can be released if it was in larger public interest. So this data could be released then, but this prohibition, which was qualified, has been converted into total prohibition under Digital Personal Data Protection Act of 2023, which amended this qualified prohibition into a total prohibition. That means this personal data cannot be released under any circumstances. So before, I hope this three points you can interlink them and you can connect them, that before this 2023 Amendment Act, this was a qualified prohibition that the citizens' data cannot be released, but if it is in larger public interest, there is some threat, then it can be released. But under this act of this amended Act of 2023, this qualified prohibition was made into a total prohibition, that the citizens' data cannot be released. So this was the amendment. And also under this act, certain information we have seen can be kept in secrecy or can be kept hidden if it is in interest of national security and sovereignty. Now talking about the amendment, so this is one more thing. The National Campaign for People's Right to Information, popularly known as NCPRI, they contended that implementing this measure would hinder the conduct of social audit. So which measure? This one, this Data Protection Act of 2023, which prohibits the release of the citizens' data. So this National Campaign for People's Right to Information, they conduct these social audits for the beneficiaries which receive ration through this TPDS, which is our targeted public distribution system, whether that they want to check it through this citizens' data, that whether that targeted delivery had been achieved or not achieved. So this has been complained by the National Campaign for People Registered to Information, that if this citizens' data would not be released under any circumstances, if it has been made this total prohibition, how would we will be able to conduct these social audits? So this is one of the criticism this amendment of 2023 has faced, that the citizens' data cannot be released under any circumstances. So criticism number one is that it would hinder the conduct of the social audits. A community member obtains a list of receiving ration, as I said, through public distribution system. There are a lot of the acts, for example, these are National Food Security Act. The BPL families get rice, wheat and coarse grain 5 kg. Before COVID, they used to get these 5 kg each, but now during the period of COVID, it was increased to 10 kg, and again it has been reduced to 5 kg only, and this is in 3:1, 3 rupee kg, 2 rupee kg and 1 rupee kg. So community members obtains a list. Community member, here we are talking about the National Campaign for People's Right to Information. So they receive this list through an RTI request only, and then they independently verified that these beneficiaries indeed received the specified items as documented or not. That if a list has been named, for example, a list has been made by the government official that A got the ration, B got the ration, C got the ration. So what this commission do, what this community do, they file an RTI request, they get that data, and then they verify it independently ki whether the things they are mentioned on paper or in actual these beneficiaries have received this public distribution system, this ration, they have received it or not. So they achieve it through RTI request only. That is why they are criticizing it, that we won't be able to conduct this social audit if we will not be able to access the data of the citizens. Now additionally, there are also apprehensions that the influential public official, they might exploit this sweeping prohibition on disclosing personal information as a means to avoid being accountable. For example, if on paper delivery has been made, what if the beneficiaries have not gotten that ration? So these officials will be exempted. They won't be accountable to anyone ki why this ration was not delivered in actual. So this is one of the criticism this amendment is facing, this total prohibition is facing. Now moving on to another amendment, the Right to Information Amendment Act of 2019. So it was once more amended in 2019, and it vested the union government with exclusive authority. So there is a commission known as Central Information Commission or CIC, which used to provide this RTI data if a request was filed under this RTI. It was the work of this commission to access that request, to provide the information on this request. So what happened in 2009, that this CIC's tenure, salary and everything was amended. Before this 2019 Amendment Act, what used to happen, the CIC officers had this 5-year term and they were getting salaries equal to that of a chief election commissioner and an election commissioner. But now this all have been amended. We can see it in this picture as well. So this is RTI's amendment bill of 2019 in this orange boxes. So what used to happen, this chief information commissioner and information commissioner, they had a tenure of 5 years. 5 years and through this RTI Act of 2005, but this was amended and it was said that center will notify. We have seen that union government had taken the exclusive authority, so center has notified the tenure to be 3 years. It has been reduced from 5 to 3 years. Now point number 2, that chief election commissioners, they were paid salaries that was equal to, as I said, chief information commissioners, they were paid salary that was equal to that of chief election commissioners as well as the election commissioner. But now the salaries will be determined by the central government, as they have taken this exclusive authority. One more point, if such officials were receiving pension or other retirement benefits, their salaries will be reduced by an amount equal to of the pension. So this was in RTI 2005 only, but now this provision has been completely removed. This pension provision has been completely removed, that if an official was receiving pension or other such retirement benefits, so their salaries will be reduced by an amount which was equal to that of the pension. But now this provision has been deleted. So all these changes has been made in 2019, and the center, the union government has been given the exclusive authority to appoint these chief information commissioners, these CIC officers, and to determine the tenure as well as salaries of information commissioners who are responsible for educating appeals against unsatisfactory or non-existent responses to the RTI. So this is basically the work of a CIC officer or the chief information officers. Now, is it undermined? Is this RTI? Does these amendments undermine the authority of the RTI? So let's see. The RTI Act implementation is dependent. Now this Act's implementation is dependent on subordinate rules which are made by the union government and the state government. For example, some matters are left at the discretion of the state governments only. For example, a simple matter of what payment method should be used, what payment method a public authority can accept is left for the states to decide. So the states can decide that what will be the mode of the payment for this RTI request. Now, what is the limitations to this RTI Act? So, number one, people can misuse it for accessing some other kind of information as well. Now, there is low public awareness about this act, specifically in the rural areas. So, rural areas don't have that much access to education or the basic education. So, there is still low public awareness. So, many people don't know the use of RTI till date or till present. There's huge backlog and delay in disposal of cases. Now there are a lot of people also who file these RTI acts to get this information, to access the information, but because of lack of, there are not too many information commissioners available. There's a vacancy for CICs and ICs and other working officials. That is why there is a huge backlog as well as delay in these disposal of cases. Number 4 is dilution of the law. This dilution of the law is related to the Amendment Act of 2019, the changes made in the 2019 amendment of this RTI. And then there is issue of enforceability. These both points are interlinked, that who will enforce it. Some matters are at the discretion of the state. Otherwise, the union government has been made this exclusive authority. So they have basically encroached all the powers. They have taken all the powers in their hands. So if this act has some positives, so it has some negatives as well. So these are the limitation of this act. And I hope you found the session interesting. If you find it, please like the video and subscribe to the channel. Thank you.